representing Bayer PLC and NHS Darlington CCG and others.
May it please your lordships, your ladyship, I appear on behalf of the Appellant Bayer PLC, together with Miss Mackenzie. My learned friends Mr. Delamere QC and Mr. Krishnan appear on behalf of the other appellant, Novartis Pharmaceuticals. Mr. Locke QC to my far right and Mr. Blundell appear on behalf of the 12 respondent clinical commissioning groups, the CCGs. Turning to the interested parties, Mr. Peretz QC appears on behalf of the Secretary of State. Miss Cars-Frisk QC appears on behalf of the ABPI, the Association of the British Pharmaceutical Industry, and Miss Wakefield QC appears on behalf of Roche Products. I hope that the court has a core bundle, 2 supplementary bundles, 3 unagreed bundles.
And 4 bundles of authorities. It's all very symmetrical. 1, 2, 3, 4. Yes, we do.
I'm grateful. And in terms of skeletons, there's a skeleton from each party apart from Roche. And
well, in the case of the 2 appellants, there's a joint stuff.
A joint skeleton, yes, I'm grateful. And then there's a joint supplementary skeleton as well from us, and a supplementary skeleton from the CCGs.
And permission has been given on the supplemental skeletons, I think.
I'm
yes.
grateful. There is the matter of Novartis's application to admit evidence. The court may want to proceed, at least initially, to hear my submissions and those of Mr. Delamere and make any decision about what to do about that evidence as we go along. If
that had been our provisional view, is that the joint view of counsel?
Certainly, for my part, we're content to proceed in that way.
More, I think, a question of whether Mr. Locke is content.
Oh, I wouldn't seek to dissuade you otherwise.
That's very helpful.
I'm grateful. The timetable, there have been discussions about the running order and timetable. Where we've landed, subject of course to your lordships and your ladyship, is that after our opening, Mr. Locke wants to respond, leaving the Secretary of State and the ABPI to follow. Roche does not want to make submissions. I should say, we had suggested the Secretary of State should come higher up the batting order, but Mr. Locke and Mr. Peretz both want to keep submissions in that order. It had seemed to us the Secretary of State's role was a little more important than that of a typical intervener. But be that as it may, assuming we stick with the conventional order, that has led to some debate about whether, if Mr. Peretz departs very significantly from his submissions, as set out in his skeleton, the CCGs might exceptionally have a short opportunity to reply before our reply.
On general principles, if new points come up, which there wasn't an opportunity to anticipate, the parties affected will always have the chance to say something.
I'm grateful. I was simply going to say we should, from our part, we wanted to see how matters develop, but you won't be surprised to hear we aren't thrilled about the prospects of the CCG having an additional opportunity to respond, unless, as your lordship says, a genuinely new point comes up.
Let's see how we go.
In terms of timetable, the proposal is that Mr. Delamere and myself will need today and most of tomorrow. We will be as concise as we can be, but there are a lot of grounds and sub-grounds to get through and significant amounts of material to introduce. Then Mr. Locke, on behalf of the respondents, has indicated he needs a day in response. Mr. Peretz, for the Secretary of State, expects to be about 2 hours. And Ms. Cars-Frisk, on behalf of the ABPI, has indicated 30 minutes. So that should, with a little bit of room for manoeuvre, bring us to our reply on the afternoon of day 4, Friday.
Yes, well, this was listed for 4 days. I'm bound to say it's the view of all the members of the court, having had a good deal of reading time, which we've taken advantage of, that we would be rather surprised if the full 4 days were necessary. I know courts always think that. It may be, as you go, that there were areas which we can tell you, we've done our reading on this, we don't need quite as much background, but we're prepared to trust you, and we'll see how we go. But don't feel obliged to fill the full 2 days.
Well, speaking for myself, my lord, I certainly won't, and I will genuinely rattle through.
You and Mr. Dama have made what seems to you a sensible split. You're not going to be reproducing.
Absolutely not, my lord. I was just going to come on to that. I'm grateful. I don't know whether the court has. I've handed up a very basic sheet, one page deliberately, which is just intended to be literally no more than headings, because there are enough grounds and sub-grounds in this case that, at least at the outset, I venture to think it might be a useful reference tool. And what we've agreed between us is that I will introduce the appeal and then address the court on ground 1. Then Mr. de la Mare will make submissions on grounds 2 and 3A to C. And I should immediately say that we heard this morning, a few minutes ago, from Mr. Locke, that he no longer pursues his arguments on ground 3C, the industrial preparation point. That's paragraphs 229 to 231 of the judgment. He stresses that's a limited concession, obviously it is, but 3C is no longer live.
So sorry, Mr. de la Mare is
2
going to...
and now 3A and B.
Yeah, okay.
And then I will bob up again at the end of our allotted time to address grounds 3D, 3E and 4. We will try to manage that elegantly. I appreciate it's not an obvious split, but it may at least provide a refreshing change of voice from time to time, and it's the best we've been able to do. This appeal concerns the policy of 12 clinical commissioning groups, CCGs, located in the northeast of England for the treatment that the NHS trusts from whom they commission services should offer for wet age-related macular degeneration, wet AMD. And wet AMD, as the court has already seen, is a serious but relatively common condition. It particularly affects elderly patients, and if it is left untreated, causes blindness. 2 products, Eylea, which is produced by my client, Bayer, and Lucentis, which is produced by Novartis, have been authorised to treat wet AMD and approved as cost-effective by NICE. Yet the CCG's policy is that instead of these products being the preferred treatment option for patients, a third product that is not authorised to treat wet AMD should be preferred. That product is known often as compounded bevacizumab, or CB for short. And as we will come on to explain, what is meant by CB is that a cancer drug, Avastin, which contains bevacizumab as its active ingredient, is manipulated in a process described as compounding or aliquoting, as Mr. Peretz and the Secretary of State prefer, to make a new product. The reason for this change is to save
Aliquoting is slightly more accurate, isn't it? Because compounding suggests, at least to a non-scientist, the addition of some other substance. But the
I-
process of aliquoting, if I've understood it correctly, is essentially taking a much smaller part of a vial containing the product and administering it by a different route, and you'd say for a different condition. But the product itself is not chemically changed. That's why, to me, aliquoting is a better summary of what's happening than the word compounding.
Well, my lord, that may be right. I think compounding may be a slightly more compendious term. Mr. Peretz will correct me if I'm wrong. I think
I don't mind which is used, but I'm just pointing out a point which is of some importance when we get to the arguments in the case.
Indeed,
Yeah.
my lord. Well, if the court's content, I will probably struggle not to use the term
No, that's fine. That's
CB
fine.
or compounded bevacizumab, and as we will see as we go on, a number of the documents do use that
Yes, I know
language,
that.
but I fully accept what your lordship says. The appellant's case, in a nutshell, is first that the CCG's policy is unlawful because it's predicated upon an unlawful supply of CB, and second, that a policy which instructs or encourages the NHS trusts to prefer a drug which is not authorised for treatment of wet AMD on cost rather than clinical grounds is unlawful when authorised alternatives are available. And I stress those final words.
Can I just have that? I've got the first after that. The policy is unlawful because predicated on an unlawful supply.
And second, which is coming in to the grounds encapsulated in grounds 3D and onwards, a policy which instructs or encourages the NHS Trust to prefer a drug which is
Hang on
not
one second.
authorised.
Hang on 1 second. To prefer a drug. Yep.
Which is not authorised for treatment of WAMD, wet AMD.
Yep. On cost
On
grounds.
cost rather than clinical grounds is unlawful when authorised alternatives are available.
And authorised means with a marketing authorisation
Yes, my
under
lord.
the directive.
Right, yes. And as I've already mentioned, in this case, there's the additional feature that those alternatives are not only authorised, but in fact have been approved as cost effective under our system for assessing cost effectiveness of medicines. At the outset, I wanted to make 3 preliminary points. Then I want to show the court the challenged policy documents before I come on to ground 1. Slightly unusually, Mr. Delamere and I have agreed that I should not introduce the legislation. The reason for that is because it's not directly relevant to ground 1. Mr. Delamere is going to need to go to the legislation in some detail when he comes to grounds 2 and 3A and B, and it therefore seemed to us that a high-level introduction would risk duplicating and adding to time unnecessarily, so I hope that's acceptable. So my first preliminary point is about perspective. The CCGs argue that they are being unnecessarily thwarted in their cost-saving measures by commercial interests. That's really the essence of their case. We say there is a quite different way to approach the issues that arise in this case, different from that taken by the CCGs, and to be candid about it, different from the approach taken by Mrs. Justice Whipple at first instance. If this policy is held to be lawful, it will introduce a system that prefers an unlicensed medicine over licensed alternatives. Not because that would be better for individual patients on clinical grounds, but for wider cost-saving reasons. And we are talking here about taking a cancer drug, a different and larger molecule than either Lucentis or Eylea, and injecting it into patients' eyes without that having been authorised by the responsible regulator, in this case the EMA.
Well, without the marketing of such a drug having been
Indeed,
authorised.
It's a
But that-
fact that it has not been.
Of course, I understand
authorised
that,
for
but
use.
the way you put it is without the injection into the eye having been authorised by the responsible regulator. That is not, as I understand it, what a marketing authorisation does. It authorises the placing on the market.
Well, my lord, obviously we're going to
Yes,
come on
okay.
to those points.
No,
in
all right,
considerable
I'll resist the
detail.
temptation to get too quickly into the argument. Yeah.
The point I'm making at the moment is that what's occurring in our submission obviously introduces risks, principally arising from what I'm calling the compounding or aliquoting, if your lordship prefers, and best described as manufacturing or quality risks. And just as an aside, and to be clear, when we talk about safety issues in this case, manufacturing and quality risks are primarily what we are talking about. And that is a separate issue from the safety of the product as designed. So the extent to which safety is an issue, I should say, has been contested in this litigation, with the CCGs stressing that the formulation has not been shown to be unsafe. But that's not our point. Our point, reduced to its essence, is that there aren't the necessary guarantees of quality of the actual product that will be used, and that is a matter that the legislation regulates just as much as it regulates the safety of the formulation.
So I don't understand then what's the point about it being a different and larger molecule? I mean, that doesn't
Well,
have any bearing on quality of manufacture and
my lord, it's simply to point out that it's as it happens, it's not a case of the identical chemical
yes.
being
Did you not
manipulated.
complain about risks arising out of it being a different molecule than that?
Well, my lord, both of our clients, for different reasons, have not pursued use in the eye. There's material in the evidence explaining why, because of it being a larger molecule, it's not thought to be as suitable. And indeed, I think there's some evidence from Roche as well to similar effect. But I'm not on that point at the moment.
What you're saying is that the tests that were carried out in order for those authorities that have declared this to be a safe way of treating the condition were using properly compounded product, and that you don't contest.
Yes, manufactured. The test to grant a marketing authorisation to bevacizumab, Avastin, for use in cancer, we're assessing the risk-benefit ratio.
No, I meant the tests that were carried out in order for those authorities to...
The Cat and Ivan studies,
Yes.
Your Ladyship. Yes, I'm grateful.
Yeah.
Yes, we do have a point about the fact that the drugs used in those trials were obviously necessarily prepared under particular conditions, and there's no idea at all whether those conditions are repeated, simply because this is all operating in an unregulated space. Yeah.
medicine or special in each case with a full marketing and manufacturing license.
Yes, Mr. Delamere asked me to mention, which is perfectly true, that those would have been manufactured as either investigatory medicines or specials, specifically for clinical trials.
So there would be a license supervised by the MHRA.
There is now a whole clinical trials directive, but I don't think we need to get into that. So, coming back to my first preliminary point about perspective, the court will appreciate that regardless of the merits of permitting what's proposed for bevacizumab in this particular case, endorsing the policy would have, we say, wider regulatory repercussions across other medicines.
Not sure I understand that.
Well, if the CCGs are correct, we say that would mark a shift, a fundamental shift in the system, a carefully constructed and detailed system for regulation of medicines that's developed over the past 50 or so years. And indeed, that point's a point that Jeremy Hunt, at that time Secretary of State for Health, made in a letter to the CCGs in March 2015, when he observed it would not only be unlawful, but also against the public interest to attempt to set aside the licensing system purely to cut costs.
Yes, but the question is whether it is setting aside the licensing system.
I accept that, my lord. But that's the view expressed then by the Secretary of State for Health. I wasn't going to go to the letter now, but if you'll note, it's at supplementary bundle B, tab 25, page 474. And it's a point that the MHRA reiterated in 2017, including in response to this policy, and which I don't, for my part, understand them to depart from now after they've carefully reviewed their position. Before coming to our second preliminary point, I should just say, for the avoidance of any doubt or confusion, that we are using the terms authorised and licensed as synonyms. And I think I can speak for all of the parties on this. As your lordships and your ladyship will have seen, authorised is used in the EU legislation and other documents. Licensed is very often used domestically, but nothing turns on that I'm aware of, at least. And Mr. Peretz is helpfully shaking his head. My second preliminary point is that this is a case where precision and detail really matter. The CCG skeleton, no doubt for good forensic reasons, frequently does not fairly or fully outline our submissions, and I do need to urge the court not to accept uncritically what the CCGs say about how we put our case and what the issues really are. And in a case with many points, your lordships and your ladyship may well, by the end of the week, think too many points. It's not helpful if the respondents are not meeting the case which we, and in fact also now the Secretary of State, in fact put. To give an example, the CCGs wrongly describe the purpose of this litigation as being to prevent NHS doctors from being able to use Avastin for wet AMD patients. And that's paragraph 5 of their skeleton. On the contrary, we do not for a moment question the individual prescribing discretion of medical professionals, nor do we dispute that a policy which sought to do no more than neutrally inform the exercise of a doctor's discretion to select between licensed medicines would be outside the scope of EU law. Doctors can and ought to have regard to the need to manage resources properly, a point that is emphasised by the CCGs, but with respect, that misses the target. This case is very far from that situation. This case concerns a policy which seeks to entrench a systematic preference for an unauthorised medicine on grounds of cost. And we submit that crosses a line. So ignoring the detail of this policy,
Sorry, you've more than once, I think, used phrases like preferring unauthorised medicine on grounds of cost. The sting is in the unauthorised, isn't it?
well, and indeed we're going to come on
On
to,
grounds of cost, there's no doubt it is cheaper. That in itself is not irrelevant. It's not illegitimate. It is the fact that it is unauthorised, and that's really what we've got to focus on, isn't it?
indeed, my lord, and my lord will have seen that there was a certain amount of debate below about is it properly described as unauthorised or off-label. I have to say that the focus of the debate has shifted a little bit from that, but undoubtedly that's an issue that my learned friend Mr. de la Mare is going to come to. But indeed, that there's no uncertainty that the reason for this policy is a cost one, as the judge below found. It's paragraph 3 of her judgment. But we do say that we can't ignore the detail of the policy, and indeed, insofar as one can discern the facts, the policies that exist in some other member states. And we do, that's why we say that some of the more catastrophising arguments which the CCGs put about the position in other member states also being necessarily unlawful if we're right, are wrong. We simply are not in possession of the details and the facts on those other member states. Those details would have to be considered, including requirements for exercise of clinical discretion, prior prescription, manufacturing and storage controls, pharmacovigilance requirements, and so on. All of the things which Mr. de la Mare is going to come on to address the court on. So I'm simply at this point putting down a clear marker now that Mr. de la Mare and I are not going to take up time addressing all of the respects in which we say the respondent skeleton mischaracterises or doesn't quite capture our issues. We want to explain positively why it is we say that the judge erred and that the CCG's policy for systematic preference for compounded bevacizumab is unlawful and should be struck down. My third and final preliminary point concerns the boundary between EU and domestic law. The CCG's case would have it that the subject matter of the policy is governed only by domestic and not EU law. They argue that the NHS exists in an EU law free zone, a protected bubble, in which the only things that matter are national cost management and medical discretion. At first instance, Mr. Locke put it vividly by saying that EU law stops at the door of the NHS. Now, much as the CCGs may wish it, we will explain why that is not the case, as the Secretary of State has, if I may say so, very clearly set out. Since I mentioned the Secretary of State, I should say I'm not going to deal now with what the MHRA have recently said in their clarified guidance and in the Secretary of State skeleton. We will come to that at the relevant points in addressing the court on the grounds, and your lordships and your ladyship have our supplementary skeleton. But there's no doubt that as between us and the Secretary of State, there is a lot of common ground, both about how to approach the issues and as to what the answers are. And we do say that it's an important change from the position as matters were before Mrs. Justice Whipple at first instance, that we do now have the active participation of the Secretary of State, and we have, of course, the MHRA's recent review and what they term their clarified guidance. As well as legal submissions in the Secretary of State skeleton, the court may already have seen that the review materials confirm some of the safety risks inherent in the manufacture of compounded bevacizumab in a way that makes many of the points that we sought to make below. So those materials, in fact, raise very many of the concerns that we sought to raise about quality of compounded bevacizumab, how it's prepared, stored, its shelf life, and so on. And helpfully, it very probably now means there's no need to go to the factual parts of our unadmitted expert evidence below that's in Unagreed Bundle 1. Unsurprisingly, that there's not total overlap in the matters addressed or in the emphasis given or nuance and so on, but for the purposes of this appeal, we submit the court does get what it needs from the MHRA review. So with that briefest of canters through what we say the case is about and not about, I want to come to the policy itself, which is at Core Bundle B, tab 18. It's right at the back of Core Bundle B. Behind tab A, there's a document headed Appendix 1, Proposed Policy for Adoption by Clinical Commissioning Groups. Just to explain, so these documents behind tab 18 are what was challenged. They're the decision that was challenged in both my client and Novartis's judicial reviews. It's called Appendix 1 because it's an appendix to a report which was also sent to us, which we'll come to in a moment, which is behind tab B here. But this is the document that was sent to us as what had been adopted by
Tab A is you're talking about.
all of these materials were sent to us as finally adopted. So I'm just explaining that although it's still called proposed, it was sent to us. There is a version, just for your note, there is a version as later circulated to the NHS Trust CEOs which doesn't say proposed anymore, so which looks more final. That's at Supplementary Bundle B, tab 28, pages 507 to 8. So then under the heading, we see first a section background, neovascular wet age-related macular degeneration. Wet AMD is a common condition.
Sorry, that document 507 to 8, apart from not saying it's proposed and perhaps not saying Appendix 1, the actual text is identical, is it?
It's identical apart from, I was going to come on to mention this, part towards the end of this document has
I see.
the
Well,
alternative version.
take us to it when you get there.
Okay, great. Affects people aged 50 years and older, causes severe...
I don't think you need to read all this out. We've obviously read it.
I'm grateful. I'll highlight the points I wanted to on this. So the second paragraph comes on to refer to ranibizumab, Lucentis, and aflibercept, Eylea, licensed for the treatment of AMD. both treatments have been approved by NICE for use.
Again, this is just factual stuff. You don't need to read it to us, do you? We've read
No,
it.
but my lord, if I may, there are
Yes, of
some.
course.
There start to be some figures which I do want to
Yeah.
show the court. So, the policy is recognising NICE had approved the drugs as cost effective, and of course that means there's then a statutory obligation to supply the drug if it's clinically indicated. Then the list prices for Lucentis and Eylea are given, and it then refers to the fact that there's a discount agreed in a patient access scheme. It's well known that significant discounts are often agreed, and the actual figures are confidential. Then the next paragraph is when we start to get into particularly controversial territory for this case, because it explains that bevacizumab is licensed for the treatment of certain cancers. It refers to it also being widely used outside the terms of its license, commonly referred to as off-label, and as my lord has already pointed out, that's actually a contested term as to whether it is proper to use, accurate to use the term off-label in relation to what's being done. But no doubt it's factually correct that it's commonly referred to as off-label in a number of cases. Our position is that as soon as it's manipulated, a new product being manufactured, that if placed on the market is a breach of the directive, as your lordship and lordships and my lady know. And then this is important. Avastin is priced at about £28 per injection, and I do stress that because obviously all these figures are disputed and the detail of them matters, but as I'll come on to explain, that figure shows that plainly what is being contemplated here is compounded or aliquoted, compounded bulk external supply. In particular, it simply cannot be consistent with what's come to be referred to as original vial use. I will come back to this point when I'm addressing the court on ground one. I just want to flag it now. Or yes, I said particularly. Yeah, we say it's also not consistent with the costs of mode 2. Again, I will come back to that.
But how can you sort of reverse engineer how many portions or injections that envisages getting from one vial of
Well, we've
Avastin?
got some evidence. I'm going to show the court, if I may, in due course. We've got some evidence from the CCGs about what they understand would be done in the case of original vial use, what it would cost. There's some evidence in there about how much of the active ingredient is needed for each injection if you are using the drug to treat wet AMD. So one can have a stab at it, but I'm not, for our part, the details of exactly how many, and it may vary from different manufacturer, different compounder to different compounder, how many doses they're trying to squeeze out of one vial of Avastin. That's not the point, but this figure is so starkly different from what the figure would be if it were a policy for either original vial use or internal NHS compounding.
Well, speaking myself, I got no problem. Of course, I understand your point about original vial use. I hadn't, maybe a fault in my pre-reading, picked up why this figure is inconsistent with mode 2. You say you're going to come back to that.
I will come back to that,
Right,
but
well
in
then
short,
let's get to it when we get to it.
so then we have in bold, after that paragraph, the key sentence, really, of the whole policy Avastin will be offered to patients with wet AMD as the preferred treatment option under the following circumstances. And that's the nub of it. And it then goes on to specify the circumstances, which are, in short, all new patients, existing patients if a treatment switch is being considered, and then it refers to patients being given a leaflet with the opportunity to discuss the reasons why Avastin is the preferred treatment option, and that they're free to choose one of the NICE approved treatments, Lucentis or Eylea. So we say that is a clear preference for and steer towards what we say must be compounded bevacizumab. We then come on to, it's fair to say, less important parts of the policy, I think, for the purposes of this challenge and this appeal. What the court is seeing there are the NICE mandated criteria for treatment. I would just ask the court to note that there's no mention anywhere in this document of prior prescription. Now, because of the way that the Court of Justice, the CJEU's case law has developed, that has become an issue, as anticipate you will have seen already in your pre-reading. But I just point out that there's no suggestion, there could be no suggestion, that the policy as adopted discussed a need for prior prescription. Then turning over the page, we see there's a sentence at the top which is actually, it's just factually wrong about the cost of ranibizumab. It's out of date for ranibizumab, and it was never a condition for aflibercept, but I don't think that matters greatly, again, for the appeal. Then the passage which disappears in the later version of the policy, which was circulated to the trust CEOs, and that I mentioned earlier, is the section beginning criteria, with the heading criteria for discontinuation of treatment, and ending with the brackets saying alternative wording. So the second of the two alternatives finds its way into the version which is eventually circulated to trust CEOs.
So the shorter version is omitted.
Yes, my lady. Turning over to B, I can be a little bit quicker on these other documents, but I do hope, I think it's important to show them to the court at the outset, since they are the challenge documents. This is the report that went from the CCG forum, which had been developing the proposed policy, to each of the CCG governing bodies, and then they all 12 adopted the policy. And we see many of the same statements as we saw in the policy. At numbered paragraph 3, again, we see figures, we see prices, including, again, the approximately £28 per injection. There's then, under the heading Safety and Effectiveness, a CCG summary of its view of the studies on safety and effectiveness, and dropping down to paragraph 6, again, looking at the figures, we see an estimate of the cost difference to the NHS in the North Eastern Cumbria over a 5-year period of 49 million. Now, I don't think anyone, apart from the CCGs, know how this figure or other figures that I'm about to show the court were calculated, and no doubt they're disputed in many respects, but again, the point I'm stressing, and the important point we say, is that this order of magnitude of savings could only be achieved by obtaining a bulk external supply of compounded bevacizumab.
So that's mode 4, basically.
3 and
Mode
4.
3, yeah.
3 and 4,
Three and
my lady.
Right.
3 is the...
NHS pharmacy to another hospital.
Yes, so for example, I was going to come to this, but
No, that's
One of-
fine, just to clarify that, thank you.
I'm grateful. And over the page, paragraph 7, the legal position on Avastin is summarised by none other than David Locke, QC, in the BMJ in April 2015, and then it refers to another article, goes on to discuss these articles. Then there's a heading, support from providers, referring to a range of studies. Next section discussing draft NICE guidance. We now have the finalised, as the court will know, the finalised January 2018 guidance, so that's been overtaken to some extent. Then over the page on 623, a section proposed way ahead. And another heading, engagement with service users, and I would just draw attention to paragraph 18. Using their feedback, and there's referring to the key stakeholder groups, we were able to revise our patient leaflets that will be given to new wet AMD patients at the time of their first consultation attached. And we'll come in a moment to the drafts of the patient leaflets that were circulated and were sent to us. So this was a very strong direction being given to the trusts about the policy that would be adopted, including quite detailed patient leaflets that were being drafted and disseminated down to the trusts. And then, in terms of figures, finally over the page at paragraph 24.
23 is actually where Appendix 1 is springs off from.
Yes, my lord, I'm grateful. We see another estimate of savings. It's a different figure, so we had 49, now we've got 43. But again, the detail, we say, doesn't matter. The important point is the magnitude. And finally on this document, at paragraph 25, it concludes by saying the proposal is to implement this new policy from August 2017 onwards. So the CCGs wanted to be up and running right away with this policy. It's not a question of causing, new facilities are built to compound bevacizumab in-house. It's about, and we'll see some of the contemporaneous correspondence bears this out, it was about buying in bevacizumab from an existing established source and obtaining, therefore, the maximum cost savings that could be obtained. So this policy published, sent to us at least, August 2017, and intended to be implemented right away. Coming on to tab C, but I can be even quicker on this one, I hope. This is appendix 2 to the report, and there's some Q&As for clinicians.
Am I not right in thinking that these are no longer challenged as such?
It's right that there was a ground below that challenged the patient information leaflets specifically, and that
Also the Q&As. I've remembered that wrong, have I?
repealed. Maybe the Q&As, yeah, Q&As as well. I'm grateful.
So,
But it's important to see we submit the entirety in buyer's grounds.
if it's relevant to the existing challenge, by all means show it to us, but I just wanted to be clear that these are not challenged as such.
Well, our challenge, we define the decision as encompassing all of these documents because they were sent to us as a package.
Right. The challenge to these documents as such is not persisted in. It says so in the skeleton, that doesn't
there's no separate appeal. That's absolutely right, my lord.
Thank you. That's what I was trying to get at.
So this focuses on really focuses on criminal offences and negligence, and the risk of a complaint to the GMC. None of which is directly on point, but it is worth, we say, glancing at one paragraph over the page on page 626, all as part of the context of what the CCGs in reality were doing. Yeah. It's under the question about halfway down the page, could legal proceedings be brought against NHS Foundation Trust employing clinicians as a result of this policy? And the second paragraph of the answer is of some interest. The CCGs accept there is a theoretical possibility that an NHS Foundation Trust will be made defendants to judicial review proceedings as part of a challenge to this policy. In that highly unlikely event, CCGs will almost certainly be co-defendants of common interest with the NHS Foundation Trust. The CCGs agree that they will indemnify any NHS Foundation Trust against any legal cost liability arising out of related to judicial review proceedings brought against any NHS Foundation Trust as a result of acting in accordance with this policy. So the NHS trusts, who the CCGs now say would be the proper target of any challenge, were at that time said to be highly unlikely to be defendants. And we submit that gives a truer, all of these documents read together give a truer picture of what the policy properly, objectively and purposefully interpreted in fact means. Coming over to D and E are the patient information leaflets. So on the version at D is Appendix 3 to the report. And again, you'll see many similar statements to those we've seen already, albeit put in slightly more layperson's language. I wanted to draw particular attention again to the figures that he used. So under the heading, there are non-clinical differences between these drugs that you need to be aware of. The third paragraph, beginning the main difference between these three drugs is the cost to the NHS. Compared to Avastin, the licensed drugs cost the NHS at least 20 times more. If Avastin were used to treat all patients with wet AMD, it would save the NHS in England at least £102 million each year. Now again, we are not at all, well, we don't know where any of these figures come from, but our point is that is only consistent with compounded and from an external supplier, from an established source of compounded bevacizumab. And then the rest of this document, what will this mean for you? Second bullet, if you choose Avastin, you'll be asked to sign a form giving your consent. We'll see some of the correspondence later on. There's quite a debate about the extent to which consent is needed. And the final bullet says if you're treated with Avastin, you may be able to start your treatment earlier than with the other two drugs. The final document behind E, I'm not going to go through. It's somewhat confused layout, at least as it emerges in printed form. It's another version. It contains the same figures for savings at page 632. But we do say that all of this, and I'll come to this in more detail under Ground 1, shows that the CCGs were not detached from the implementation of this policy. Far from it.
the figure of 621, figure of 49 million on page 621 has a footnote which refers to something that one can no doubt at one stage we find online. Do we have that in the...
We don't have it in the bundle, and I don't think we had it at first instance either.
That because it doesn't shed any light on how you calculate 49 million or the
I certainly haven't been, it hasn't been suggested to me that it does, my lord. We can have a look at it, of course, either over the short adjournment or at lunchtime to
Yes.
double check that. Could I also just mention, and then it may be convenient to have a short pause for the shorthand writer who's looking
Well,
happy at that idea.
I think we were told that when the shorthand writer gave our approval, there would not be any request for breaks. I don't want to be unkind, but we lose a lot of time if that happens.
I'm in the court's hands, of course.
I'm sorry that does, I'm sure, come as bad news to the shorthand writer, but so we were told in terms that wouldn't be requests.
I didn't appreciate that, my lord. So. Could I just, I think I misspoke earlier, point of detail. Apparently I referred to nice guidance when I should have referred to a nice guideline at one point. I think when I was referring to the January 2018 guideline. There is a point of distinction. The guidance that's produced are the technology appraisal guidances, which have this binding statutory effect. Guidelines are, as their name suggests, mere guidelines and don't have the same statutory effect in terms of a requirement to for medicines to then be dispensed on the NHS if clinically indicated. So I come then to ground one. And this concerns, as your lordships and your ladyship know, the approach which the judge took to the lawfulness of the policy. Mrs. Justice Whipple found at paragraph 198 of her judgment that the test was whether the policy was realistically capable of implementation by the NHS trusts in a way which does not lead to, permit or encourage unlawful acts. And she derived that test to a considerable extent from the decision of the Court of Appeal in the Tabac case. And I will show the court why we say that was a misreading of Tabac and not the true test. But more fundamentally, we say it led the judge to accede to the CCG's invitation to approach the issues in a hypothetical way, divorced, we say, from the reality of how the policy was envisaged to be implemented. And instead, we say that the court must ask whether the policy, interpreted objectively and purposively by the court, would lead to or encourage unlawful acts. And that is not a hypothetical exercise, rather it's a predictive exercise which needs to be informed by the words of the policy as well as the context in which it was introduced. And if I may, I'm going to make my submissions under this ground under three broad heads. First, the test, and that will encompass the case law, especially Tabac, also Gillick, Letts, and other cases to which the CCGs refer. My second broad head of submission is the policy and how we say the test applies to this policy. And then the third head is our alternative submission, that even if the judge was right about the test, she misapplied it to this policy. So starting with the test, I wanted to go straight to tabac because the judge put considerable weight on it, as I've said, and indeed so do the CCGs. That was a case concerning a number of policies giving guidance to the various agencies involved in the process of deciding on conditions to be imposed on prisoners following release on licence.
Well, can we?
Yes, I was about to turn it off. I was just going to introduce it briefly, but it's at Bundle D, tab 38. And we say, and I'll come in a moment to the detail, but we say the crucial distinction between the facts of that case and our case is that the substance of the challenge there was a risk of unfairness arising from a lack of fair opportunity to make informed representations. So the substance of the challenge was a procedural fairness one. And I don't know whether the court would like me to go through the head note, but the facts are shortly summarised, but I think I've given on my feet enough of a summary of what it was about for our purposes.
Yes.
You can see that the appeal was dismissed, but then if we go, please, to page 999, paragraph 29, where the essential complaint is summarised. The essential complaint made by Ms Kaufman is that the policy documents described above contain no provision for an offender to be informed in advance of proposed additional licence conditions, and of the basis on which their inclusion is proposed, given an opportunity to make informed representations, and so on. Various fairness concerns. So it was squarely a procedural unfairness challenge. Then turning over to 2 pages to page 1001, paragraph 35, the sidelined passage towards the bottom, and this is a passage on which the CCGs rely heavily. The question to be asked in the present context is a more straightforward one, namely whether the system established by the guidance in the policy documentation is inherently unfair by reason of a failure to provide the offender with fair opportunity to make meaningful representations about proposed licence conditions. If it is, then the guidance itself may be found to be unlawful. If it's not, the correct target of challenge is not the guidance, but any individual decisions alleged to have been made in breach of the requirements of procedural fairness. And pausing there, those observations are being made in the context, expressly in the context of this challenge, which was a procedural unfairness one. Going on, then there's reference to the Refugee Legal Centre case, which the judgment below referred to, the CCGs had cited. I don't think there's any need to spend time on the Court of Appeal's treatment of that case, and therefore move on to page 1005 on the bundle pagination, paragraph 46. The test applied by the judge, heading above that. The relevant law was considered by the judge.
Who was the judge below?
Mr. Justice Cranston. Mr. Tillman suggests I should flag that paragraph 45 draws draws the previous authorities together in a summary, which I'm grateful. Paragraph 46, the relevant law was considered by the judge. He said that the authorities recognise three bases on which a court can conclude the government policy is unlawful. First, it's well established that a policy which, if followed, would lead to unlawful acts or decisions, or which permits or encourages such acts, will itself be unlawful. Gillick. And I will come to Gillick shortly in a moment. Secondly, it was established in Munja's case, the test in Article 3 cases, is whether a policy exposes a person to a significant risk of the treatment prohibited by the article. The third basis is that laid down in the Refugee Legal Centre case. And then there's reference also to the medical justice case. And there's then a fairly lengthy quotation from the judgment of Mr. Justice Cranston below. I don't think there's need to read that, but I wanted to show the court paragraph 46 because that leads into paragraph 48, which is really where we get to the meat of.
So when he's talking about the third basis there, that laid down in the Refugee Legal Centre case, what is that? Where can that be?
So that is it's introduced at paragraph 36 and then paragraph 45.
But is that a very high risk, if not an inevitability?
Asking, well, at 45 it said whether the system established by the policy is inherently unfair.
Oh, I see.
But I think you need to look at the discussion, don't you, at paragraph 36 of this judgment. And therefore at 6 and 7 of your Justice Sedley's judgment in the Refugee Legal Centre case, which is where the concept of inherent unfairness is formulated.
Yes. My point is that those are all procedural unfairness cases.
What, the Refugee Legal Centre case?
Yes. That's
about the fast track.
Yes.
Indeed. So, coming back to paragraph 48, Lord Justice Richards says that's a thoughtful and challenging analysis. It will be apparent from what I've said above, I don't subscribe to the entirety of the judge's conclusion. Insofar as he puts Munjaz's case to one side, I agree with him, so that's the Article 3 category. Where I disagree with him is in the use he makes of other authorities. First, I would also put Gillick's case to one side. He was concerned with the reviewability of guidance on the ground that it was erroneous in law and would therefore lead to unlawful decisions. That's a materially different issue from an issue of procedural unfairness that arises here, in relation to which the decision in the Refugee Legal Centre case is directly on point. I've explained how I read the decision in that case. It concentrates on whether the system established by the relevant policy is inherently unfair. So that's where the inherent unfairness test applies. It goes on, does not reject the test of unacceptable risk of unfairness, effectively equates an unacceptable risk of unfairness with a risk of unfairness inherent in the system itself, and then refers to the Court of Appeal case in the medical justice case, which is another case that's been relied on by the CCGs here. Again, a case about the fast track system. Again, procedural unfairness case. And then at 49, in summary, I take issue with the detail of Mr. Justice Cranston's analysis and think he expressed the test erroneously when he said that what the authorities demand is that the policy must lead to unlawful action or that there be a very high risk or inevitability of that occurring. Nevertheless, it seems to me he was correct to view the relevant threshold as a high one. But my lords and my lady have a point. the simple point I'm on at the moment is that all of that was stressing that a procedural unfairness challenge is materially different to a review of guidance on gravel or policy on
Myself, I've got that point. Yes.
erroneous in law. I'm grateful. For the court's note, the judge did rely on the Refugee Legal Centre case. That's at paragraph 197, little 3 of the judgment. The detention action case, which we have at Bundle D, tab 40, is another case on which the CCG's placed considerable reliance and is again a procedural fairness case. In fact, I'm sorry, I think that's the other fast track challenge.
They
to
were
the
both
fast track
they were
immigration
both
rules.
they were both challenges to
They
fast
were.
track.
Those two cases were, yes, the Refugee Legal Centre case and the detention action case. So those cases are all considering whether a system for challenging adverse findings is so unfair as to be unlawful. And we say that's a quite different question from whether what the policy says is premised on an error of law. And that's why we say the test developed by Mrs. Justice Whittle is conflating these two lines of authority. On the one hand, the procedural unfairness line, concerned as it is with risk and inherent unfairness, and on the other hand, the erroneous in law line. So the question here, we say, is will this policy lead to unlawful decisions, or to use the let's, slightly more developed and articulated let's language, will it lead to permit or encourage unlawful decisions?
Well, although you're obviously right to make the point about the subject matters, don't you have the same underlying question arising whether the unlawfulness consists of procedural unfairness or some other unlawfulness? Namely, will the policy inevitably produce that unlawfulness, or is there merely a risk that it will?
Well,
So, while absolutely understanding the point you've just made, you've still got to tackle the question about whether the policy necessarily leads to a substantive unlawfulness, or whether it does so or not depends on how it is implemented.
well, my lord, I will come on to obviously this question of is it a hypothetical question, or do we need to look at the actual policy as it was introduced and read objectively and purposively? But we do submit that if it's premised on an error of law, which we submit this policy plainly was, then following Gillick and other cases which are better analogies for our case, the test is, will it lead to unlawfulness? Not is it certainly going to, or is it inherently going to, or any other gloss on it that the CCGs may wish to put.
Well, perhaps we're going to have this debate after we've seen the authorities, but it seems to me to ask, will it lead, if it will lead to unlawfulness, the answer is obvious. There's not a problem. The problem is, well, it may lead to unlawfulness or it may not, depending how it's done. And that's the problem you've got to face up to here. You're firing an Aunt Sally to say that if it will lead to unlawfulness, then it will be unlawful. Well, of course, but what if it may or may not?
Well, my lord, that perhaps your lordship is therefore coming on to my second
All right,
position about
note my concern
what
about
is
that.
this policy actually doing. But at the moment I'm on the prior question of the test that the judge articulated, which we do take issue with, and we do say that she was, with respect, conflating two lines of authority in an unhelpful way, and that then led her, we say, to consider, is this policy theoretically capable of being implemented in ways that may not be unlawful, depending on the facts. And we don't say that we say that's not the correct approach, nor is it correct, as the CCGs now seem to suggest, that the policy must introduce a certainty of unlawful actions. The test is simpler than that. It's will it lead to, permit or encourage unlawful decisions. Before coming to the Let's case, which, as I've said, we submit contains a helpful articulation of the test, a word about two cases, Gillick and also the West Berkshire case, on which the CCGs rely. So first Gillick, which is at bundle C, tab 30. And it's a very well-known case, so I hope it will be acceptable if I simply go to the key passages that are relevant. It's of course a very important starting point in these cases, because it established at the highest level and more than 30 years ago that a policy could be challenged on the basis it contains advice that's erroneous in law. But the CCGs, in their skeleton argument, take a passage from the speech of Lord Scarman, we say out of context, and seek to use it to argue that there must be a virtual certainty of unlawful actions by those relying on a policy before a court will declare it unlawful. But we say that the reason why their lordships in Gillick were focusing on whether a doctor would ever, I stress ever, be acting lawfully in prescribing contraception for a girl under the age of 16 was that the memorandum in that case stated that it was only in exceptional and unusual cases that contraceptive advice and treatment could be given without parental consent. And we can see that conveniently from the speech of Lord Bridge, which is starting at page 803 of the bundle. Just above the letter G. The Lord Scarman says, I think it must be recognised that the decision, that's the decision in the RCN case referred to above, does affect a significant extension of the court's power of judicial review. We must now say that if a government department in a field of administration which it exercises responsibility promulgates in a public document, albeit non-statutory in form, advice which is erroneous in law, then the court, in proceedings in appropriate form commenced by an applicant or plaintiff who possesses the necessary loci standi, has jurisdiction to correct the error of law by an appropriate declaration. And it then goes on to discuss, it's slightly less relevant, where the issue raises questions of social and or ethical controversy, the court should exercise its jurisdiction with restraint. But then coming to the next paragraph on page 804, if I may, my lords, the memorandum in expressing the view that in exceptional and unusual cases it may be proper for a doctor to offer contraceptive advice and treatment to a girl under 16 without the knowledge or consent of her parent, guardian or other person in loco parentis, implies that the law does not prohibit the doctor from so acting. The exceptional and unusual cases contemplated are clearly not confined to cases of children abandoned by their parents, and so on. And then the final sentence, to succeed in her action against the department, Mrs. Gillick must at least establish that, leaving aside cases of abandoned children or emergencies, the law does absolutely prohibit the prescription of contraception for a girl under 16 without parental consent or an order of the court. So the issue there was, is it erroneous in law to say that there are such exceptional cases? That was the language of the policy. By contrast here, the CCG's policy does not say that it's only in exceptional cases that bevacizumab may lawfully and should be compounded. On the contrary, it introduces, as we've seen, a blanket preference for CB without qualification.
So you're saying that in Gillick, if the guidance had not included guidance that this should only be done in exceptional, unusual circumstances, but had simply said this is just to advise you that it is lawful for you to do this, then that would necessarily have been unlawful guidance in failing to draw attention to the fact that it could only be done in exceptional circumstances.
My lady, that actually brings me to the second case I was going to mention, the West Berkshire case, which deals with that point, I hope. That's a case on which the CCGs rely. It's a case about planning policy.
All right, well, if we're going to that case in due course, then.
Well, I can come to it now, because it's a case.
Is there anything else you want from
I
Gillick?
think that's what I wanted to show you from Gillick. It's a case about planning policy. It's at D tab 41. So back to bundle D, if we may. It's about affordable housing, planning policy and affordable housing, provision of affordable housing. Now, again, to state the obvious, it was a very different context, and the challenge was of such a different nature to ours that we submit it doesn't really assist. But what it says at paragraph 21, that's on bundle page 1073, and is the passage on which Ms. Locke, you see, relies, is that a policy does not need to spell out that a decision maker may not fetter his discretion, or to incorporate on its face that it should be subject to exceptions. So that's why, picking up on my lady's point, we don't say that you have to spell out that there will always be some exceptional cases. Trying to apply that to our policy, it couldn't be challenged simply because it does not spell out that there may be exceptional cases where the preference for compounded bevacizumab should not apply. So, for example, if a particular patient was allergic to, say, one of the excipients used, one of the substances used apart from the active ingredient in Avastin. But plainly, that's not our challenge. That's not what we're saying. We're not saying that it's unlawful because it doesn't say that there must be exceptions. We say squarely that the policy is premised on an erroneous understanding of the law, namely that bevacizumab can lawfully be compounded and supplied in bulk from external suppliers to the trusts. We don't say that it fetters the discretion.
Hang on one second. The erroneous understanding of the law is that bevacizumab can be.
Well, I'm apologise, my lord. I was paraphrasing, and I'm going to come now to precisely what we say, how we say the policy must be read objectively and having regard to all of the evidence.
I would insist then on you taking speed. Right.
But the short point I'm on here about the West Berkshire case is that we say the policy is premised on an erroneous understanding of the law, not that it fetters the discretion of those applying it or that it doesn't spell out certain exceptions. So just before I come to the policy, which I anticipate is what my Lord really wants me to grapple with, could I show the court Lex? Because we say that is a case which is closer to our case and easier to apply to the policy that we have here. That's still in bundle D at tab 39. And that was a case about the grant of legal aid for inquests under the Lord Chancellor's guidance to caseworkers concerning grant where a case falls within Article 2 of the Convention. And I don't know whether the court would like to read through for themselves, or I'm happy to read the head note just for
Give
context.
us a moment, we'll read
I'm
the
grateful.
note. Just down to the holding all the way through.
Probably
Read all-
worth
or read all of it.
glancing through.
Yeah.
So at the end of the head note, we see that where Mr. Justice Green, as he then was, gets to is that the guidance was inadequate, incorporated an error of law, and provided a materially misleading impression of what the law was, which errors could lead to erroneous decisions being taken. And if the court could then go to page 1041 of the bundle, under the heading J, the test to be applied to the legality of guidance, we see this. Having concluded there are errors in the guidance, I turn now to the test to be applied in light of my conclusions to the law. In paragraph 105, Mr. Chamberlain was, for the Lord Chancellor, advanced four main reasons. And again, it's worth just swiftly glancing through these because some have echoes with some of the CCG's points. So first, at 106, there's a point about the Lord Chancellor having a broad discretion to the content of guidance. Secondly, at 107, the Lord Chancellor either could draft guidance at very high level or write a textbook. Then over the page 108, the Lord Chancellor is not empowered under LASPO to lay down rigid constraints as to how the caseworker should approach any individual case. That has echoes with some of what's said now about the Trust's freedom. And finally, 109, he submitted the complaints about the level of detail that would not give rise to judicial review. Then paragraph 111 is a paragraph on which the CCGs place reliance, so I should show the court that under LASPO the director must have regard to the guidance, and the director would hence act unlawfully if he failed to have regard to those guidelines. Equally, the guidance itself makes clear that it sets out factors which caseworkers should take into account. Guidance has forensic bite. And then dropping down to D, D, its very purpose is to be influential. It would be most surprising if it were not viewed by the director and by caseworkers as an important guide as to the manner in which they were to exercise their discretion and take decisions to grant or refuse legal aid. As such, while it's important not to overplay its significance, it's also important not to underplay the role that it plays and is intended to play. And just pausing there, although our guidance is not statutory, we do submit that its very purpose is to be influential. And I already began to develop my submissions on that when I showed the policy documents a short time ago. It is intended to act as an important guide. Dropping down to paragraph 113, in my judgment, the guidance is predicated on the legal errors I've described above. 114. If guidance is predicated on an error, then this in principle can sound in judicial review. And this is Mr. Justice Green's, in our submission, helpful analysis of Gillick. And he quotes then the passage which I took the court to from the speech of Lord Bridge in Gillick, which we've already seen. Over the page, this is all quotations from Gillick, and there's then at paragraph 115 of this judgment, a quotation from Lord Templeman to similar effect. 116, Mr. Justice Green quotes Tabak. At paragraph 46 again, we looked at that. And then paragraph 117, Mr. Chamberlain accepted that this, which added something of a gloss to the formula used in the Gillick case, through the addition of the phrase, or which permits or encourages such acts, was a fair and accurate encapsulation of the relevant test. Ms. Kaufman for the claimant also accepted that it was applicable to a case such as the present. And then Mr. Justice Green himself adopts and articulates it. The test is hence, would the guidance, if followed, 1, lead to unlawful acts, 2, permit unlawful acts, or 3, encourage such unlawful acts. In my view, for the reasons already given, the guidance would do all of these 3 things. So we do say that's a good articulation of the test, which can be more readily applied to the facts of our case and to our policy. Will the policy, if followed, lead to permit or encourage unlawful acts?
Permit is the one we have to be careful about, but surely any policy might permit unlawful acts if it doesn't expressly say don't do them. Permit surely has to be read alongside 1 and 3, lead to or encourage. It's a term of the same sort. It must be some sort of active creation of a risk that would be unlawful acts.
For my part, I don't have any difficulty with that, my lord. I think that
Sure, I
the
could put it
phrase...
better if I'd thought about it more, but you see the point.
In the sense of sanction.
I'm grateful, my lord, yes.
Well, it does highlight seems to be a difference in this case from the other cases, that in the other cases the guidance is from the head of the department concerned to caseworkers in the department concerned who are taking decisions which will then count as decisions of the person delivering the guidance. So the person giving the guidance is telling them how to do the job that they're being employed by that person to do.
My lady, yes.
And that gives a particular flavour to permit, which doesn't, seems to me, apply here, where the guidance is being given to a different body whose decisions are not the decisions of the person delivering the policy. And the extent to which the CCGs permit or don't permit the NHS trusts to do something is rather different from the Secretary of State for the Home Department giving directions to caseworkers the board or agency or whatever, or people deciding whether to grant legal aid for inquests. It seems to be a factor in this scenario which doesn't arise in the other cases. I don't know whether there are other cases in these 4 bundles where that is the situation, but I haven't...
Gillick, my lady, certainly wasn't. Gillick was coming from on high to giving guidance there to doctors who were undoubtedly legally separate entities. But for my part, I think the word from Mr. Justice Green's articulation of the test, and it really is just the Gillick test, but it's a development of it, except the word that we've always viewed as most apt to cover the circumstances of this case is encourage, because we say that there undoubtedly really is encouragement here from the CCGs, but I'm not sure we need that. If we go back to the simple Gillick, will it lead to unlawfulness? That's another way of asking the question.
You use the expression premised on an error of law, and Justice Green uses the expression
Predicated, yes.
on an error of law, which I imagine means the same thing. But he was dealing with a case where he held the guidance actually misrepresented law. Is that part of this case?
Well, we would say so, yes.
Yeah.
We would
Well,
absolutely.
you're coming on to say what the policy means, but I just wanted to
Because,
see whether that was taken out of this.
well, yes, in the by omission, by failing to recognise that there was a category of cases where Article 2 was engaged, he held that the guidance was premised or predicated on an error of law, and we say equally here that it is premised or predicated on an error of law. That is our case. So then to my second broad head of submission and the policy, if I may. And we've already looked at the policy, but first the question of how should it be
just to be
construed.
clear, you say that the test which the judge should have applied is the test set out in paragraph 118 of Letts.
We say that's a very helpful encapsulation of the test, yes. Articulation of the test, perhaps to put it better. But it is I accept a gloss on Gillick, and we say we can equally get what we need from Gillick itself. So, coming to the policy, how should it be construed? And for that, we have the Court of Appeal's judgment in the Raisi case, which is still in bundle D at tab 35A. At least I hope it's at tab 35A. I was told that the court had very helpfully put it in.
Oh, I see. No,
Put it into the-
it's at 35. Is your point that we have it both in...
Yes.
I see. At 35, we originally had the divisional court. What's been added is the Court of Appeal in the law report.
Yes.
Yes,
So
I
what-
see. It hasn't. We haven't actually on tab 35A, but it is halfway through tab 35. Yeah.
I'm grateful. So, just to introduce the case very shortly, and your lordships and my lady may be familiar with it, the policy was an ex gratia scheme for compensation, and the issue was whether it was capable of applying to detention in the context of extradition proceedings. And the reason for, I should say, just to avoid any confusion, in our skeleton argument at paragraph 24, the propositions that we put are all accurate and supported by the Court of Appeal judgment. For some reason, citation is given to the Divisional Court judgment, and the respondents grateful that they brought that to our attention, so we've put in the Court of Appeal judgment. But the important thing is that everything we say about construction is supported by the Court of Appeal. It's a judgment of Lord Justice Hooper, a judgment of the court to which all members of the court contributed, and as I've said, it concerned whether the ex gratia scheme for compensation was capable of applying to detention in the context of extradition proceedings. There's a page, internal page 837 of the head note, little paragraph 1 of the holdings, there's a helpful articulation of the test to be applied in interpreting the policy that was in issue there, to ask what a reasonable literate man's understanding of it would be, not whether the meaning attributed by the Minister to the words of the policy was a reasonable one.
Sorry. Oh,
I'm sorry, I'm on your
at
page
the
8.
top now.
Yes,
of
page
the
8.
numbers of the top at the top.
Yes, I'm so sorry. This, because of its late arrival, it hasn't got bundle pagination, so I'm
Well,
using
it has
I have
actually,
actually
yes.
got
It's
it.
got 946A
right.
all the way through to AT. But yours
Well-
hasn't been marked in that way, so we'll use the
You'll
internal.
have to forgive me. I don't have
Couldn't matter less, but let's use the internal pagination, otherwise we won't be able to cross-refer to each other. Yep.
So 837 at top right, at little 1 is an articulation of the test. And then if we could go forward to internal page 866, paragraph 107, that's where the section on the scope of the scheme interpretation begins. And Lord Justice Hooper at paragraph 108 begins by quoting from one of his earlier judgments in the Berkshire case, where he referred to ex parte web. And that is important because this is the test that comes through at the conclusion. So, Crown against criminal injuries compensation ex parte web. Government has made funds available for payment of compensation without being under a statute to do so. It follows in my judgment the court should not construe this scheme as if it were a statute, but as a public announcement of what the government was willing to do. This entails the court deciding what would be a reasonable and literate man's understanding of the circumstances in which he could, under the scheme, be paid compensation for personal injury caused by a crime of violence. And then dropping down to 110, we can see the Home Secretary's submission in the middle of 110, submitted that the ex parte web test was no longer to be applied in the light of In re McFarland. It was and is submitted that's for the Minister to decide what his policy, to what his policy.
This is all pretty well, I can't believe any of this is controversial, is it?
Well, I'm
It's an
very
objective construction, not the Minister's construction subject to Wednesbury.
yes, I'm grateful. It's for the court to decide.
That's not controversial.
Well, I
is it?
agree. It's Tesco stores and Dundee
Well,
Council.
don't worry about what other cases, but the
Yes,
point is not
yes.
controversial. Yeah, you can take this quite shortly if this is all you're trying to show us, but
I'm-
maybe there's more.
I So objective, yes, I'm very grateful. But I think if we could go forward to paragraph 122, we see the reasonable meaning approach being rejected, which is the point my Lord's just been putting to me. 123, it's for the court to decide again. We shall use the ex parte web text whilst accepting it could be worded in a modern way. And then 124, we see the Court of Appeal's more modern articulation of ex parte web. What does the scheme mean? What was its purpose and scope? Who was the minister intending to compensate? And we then see in the rest of that paragraph, the court is looking at the purpose of the minister in promulgating the policy. And what I particularly wanted to draw attention to at the end of 124, so on internal page 871, it should be interpreted purposefully.
Yeah.
I'm grateful, my Lord. So 3 points we stress, and it may be that I'm labouring this unnecessarily, but first, ascertaining the meaning of the policy is a question of interpretation for the court, not for the author of the policy. Second, the court should decide what would be a reasonable and literate man's understanding of the policy. In other words, it's an objective exercise, looking at the ordinary and natural meaning of the words used in their context. And third, the construction is a purposive one. In other words, the policy must be construed through the lens of the purpose of its maker when it was adopted. So, looking at this policy objectively and purposively, we do say that it's a policy to prefer compounded bevacizumab supplied to the trusts from external manufacturers. And coming back to my lady's question to me earlier, that is what has been termed modes 3 and 4. And I'm very conscious that I've been bandying these modes around and perhaps should have introduced what they are.
We know what they are, but as we've read, they're central to the judge's reasoning. But
I'm grateful.
if there are particular points you want to make about them, that's another matter, but you don't need to introduce them to us.
I'm grateful. So the CCG case on this, put in a number of different ways, is that because the policy could theoretically, they say, be implemented in a way which they claim is lawful, it must be lawful. Now, your lordships have our submission, which Mr. Delamere will be developing on his feet, that we say all 4 modes of implementation now put forward by the CCGs are unlawful. But at this point in our submissions, we're stressing that the legality of the policy cannot be divorced from the reality of how, but for this legal challenge, it was envisaged it should be implemented. And we say that both because of what the case law says about looking at its meaning objectively but purposively, and also because of certain particular features of the context in which this policy was adopted. And that's the context that I want to turn to now, and under 5 heads. First, we say the CCGs were deeply involved with how the policy would be implemented. So they did not hold themselves aloof from how it would be implemented, quite the contrary. As we've seen, they developed a clinician Q&A document, and there are the patient information leaflets that we've already looked at. The CCGs were plainly trying to do everything they could to ensure that the policy was implemented as widely and easily as possible across the 5 NHS trusts.
Sorry,
within
but
that
we need to
area.
be careful. Your point that they were intended it should be implemented widely, that's, speaking for myself, obvious. That's a slightly different point from saying they were deeply involved with the implementation, which,
Well,
which
they-
is what you illustrate by saying
they were
they
involved-
provided Q&As, and because there'd be two quite different things. They could say, we're very keen you do this, but we leave it up to you how you do it. Which is, your point is surely that they didn't say that. They said, they involved themselves in how it was going to be done. Is that right?
Yes, to a considerable extent.
What extent, apart from doing the Q&As and the patient information?
That's what I'm about to
So
show.
sorry.
Oh, no, not at all, my lord. I'm sure it's frustrating, but I'm trying to build my my bricks. So, if we could just to start, I wanted to give a flavour of the extent to which the CCGs were, we say, heavily involved. Start by showing the court the documents developing the patient information leaflet. So this is in supplementary bundle B at tab 27. So this is a collection of emails, so as often happens with emails, we have to read backwards. If we could start at page 511. Sorry, I'm so sorry, that's in, I'm in tab 28, I said tab 27, 511. This is,
Sorry, no. You said tab 27, and that's where we
Yes.
are. It's page 511.
yes,
Yeah, okay.
which in my bundle is at tab 28.
Oh,
But
in
maybe
our
my
bundle it's at
tabs in the
27.
Okay, okay.
Couldn't matter less,
Let's not worry about
as
that.
long as pages are obviously more reliable than tabs. So.
Yep. So this is an email chain. So we've got to look at it backwards. What's happening here is it's a clip of emails exhibited, I think, by David Hambleton, the CEO for South Tyneside, who's one of the CCG's witnesses, to his second witness statement. They're discussing a draft of the patient information leaflet, and we have that version. If your lordships and the lordship could look going forward over the page to 512
It will help me
and
just
513.
to understand where this is going. If it is just a general point that the CCGs are shown by this to have taken an active interest in, perhaps even to have taken a primary role in the wording of the leaflets, that's fine, but does it need to be elaborately illustrated, or are there more particular points?
If I may, I do want to show
Right.
this because I think it gives a flavour which I can't convey by simply making a submission.
I'll let you go on.
It was wholly developed by the CCGs, my lord. This is a CCG project.
Don't worry, don't let me slow you up anymore. Okay.
So we've got the version of the leaflet over at 512, 513. The paragraphs aren't numbered, but then they start being discussed in these emails by reference to the numbers of the paragraphs. For your lordship's note, it's helpful to know that the paragraph at the top of page 513 is paragraph 7. If one just puts a number next to each paragraph. So, starting at the bottom of 511, hello Sean, as promised, here with a revised and abbreviated version of the patient leaflet. Text only, etc. This is all from the CCG's discussing between them. Then at the top of the page, you get some comments back on different paragraphs, as you've seen, giving them numbers. Paragraph 2, some typos. Paragraph 7, this could be used, sounds a bit like Boris's Euro lie. This is equivalent to or something similar would be my preference. Nurse is good, heart transplant's a bit random. I would say either how many more eye treatments or go for something really emotive. And that paragraph is the paragraph at the top of page 513, which is describing
Yeah, well, we've
using
seen
different
that.
figures,
Yeah.
savings that are said to be made. So we say what this is showing, it's seeking, on the one hand, it's seeking to produce a document that's as persuasive as possible, and secondly, it's seeking to make the whole process as cheap as possible, because what the email says after the paragraph describing paragraph 7 is the consent is the real issue. Is this necessary? This places an onus on the clinician who needs to consent for the procedure but not necessarily the drug, who will then have a defensive conversation in time they do not have. In other words, the CCGs want to make this as easy and successful as possible, even potentially avoiding the need for proper consent.
Sorry, well, that's a comment coming from the trust to the CCG, not the other way around. So it's the trust making the observation. It's clearly wrong, but can I just clarify, it's not the CCG saying this.
I'm grateful. So going over to back to page 510, we then see Sean Fennick from the Trust saying to David Hamilton, my view would be there would be no formal consent for the drug, just the procedure. If we mean consent as opposed to permission, then I think this will have a material impact on success. Can we, by means of the information leaflet, get to a position where Avastin is accepted, the clinical team can then give another drug if they feel necessary, the patient has agreed to use Avastin when they pitch up. And then at the top of the page, great, have a meeting booked, they want something which helps.
That's for the trust as well, isn't it? Why, your point's about,
Yeah.
so,
Yeah, we then, right at the bottom of page 509,
You get the CCGs apparently saying that sounds fine to me, Sean, in the middle of 510.
yeah,
Sounds okay.
Thanks, Sean. I think it's a really helpful comment.
oh yeah.
Yes, at the bottom of 509 is something from the...
And also at the bottom of 510 as well. Thanks, Sean. Sorry, it's in very small writing there, so it looks as if it's part of the footer, but it's not.
I think we just need to be proportionate.
Yes. Yeah. You probably don't need to mention it specifically in the leaflet at all, to be honest. The process is one for you to operationalise as you would see fit, would be my view. No doubt Mr. Locke would place emphasis on that. If you can make it work as part of the overall consent process procedure, then that should suffice. And then again, I'm grateful, my lady, at the bottom of 509, I've removed all references to signing a consent form. So, we do say that gives a flavour of the extent to which the CCGs were deeply involved with how the policy would be implemented. Second, these documents show, and further documents that I will show you in a moment, show it was an advocacy exercise seeking to persuade the trusts to implement the policy via the cheapest mode possible. We do submit that's the ordinary and natural meaning of the policy and the surrounding documents. And that included seeking to reassure the trusts about the legality of the proposed method or methods of supply when concerns were raised. And those documents start at 504. On our way there, my lords, my lady, we go past the letter that I mentioned earlier, which attaches what seems to be the final version of the policy. But 504, this is now a series of exchanges between chief pharmacists raising various concerns about the policy. So on 504, about halfway down the page, there are principles here that appear to be being compromised that go beyond what AMD. There's also an apparent difference in opinion of the law and extremely uneasy about in being commissioned to go down a path that's an apparent direct contravention of existing UK law prior to that being tested in the courts. And then I think we can go back to page 502. Near the bottom of the page. An email from David Campbell, the chief pharmacist for Northumbria, saying, I feel very uncomfortable about this, and says in about halfway through that email, the process will have lacked appropriate clinical involvement. Why not develop through existing mechanisms for medicines, i.e. APC, formulary groups, etc. Back again one page.
Remind me who NTAG are.
The nice, is it the, oh yeah, I'm grateful, the Northern Treatment Advisory Group.
That's a group of what?
They produced one of the estimates that we've seen.
Yeah, but
The policy.
who are they? Are they a CCCG sub-body or are they a trusts body? Who are they?
So,
If it assists,
Yes, thank
I
you.
might be able to say they're a regional group of pharmacists and clinicians from various NHS organisations, including, I think, representatives from both commissioners and providers.
Thank you.
great. So I was.
I should have made clear, they as Madam Friend made, they were involved at an early stage in the development of this policy because they provided some of the initial work around the clinical safety and effectiveness of the proposals.
So I'm then on 501, at the bottom of the page, this is an email from David Campbell again, saying, sorry, also meant to ask, do we know who the manufacturer is that is mentioned in the letter? So that's referring to a single manufacturer. That's
For what letter is that? I'm so
That's
sorry.
the letter at page 506, which I was going to come to, which was circulating the final version of the policy to all of the CEOs of the trust, saying it's been ratified. And the penultimate paragraph of that letter, I would also like to confirm we've identified a manufacturer who's able to supply appropriate quality and quantities of the preferred drug bevacizumab, although of course the choice of supplier is an issue for individual trusts. But they have someone.
Sorry, it's not clear to me, maybe clear to you, that that means compounded.
Well, I'm going to come on to why the costs that are given in the policy that are the driving reason for the policy mean it must be compounded.
That I understand,
Not-
but I'm sorry, I was probably reading more into it. You were emphasising a single manufacturer, and I read into that one could imply from that meant a manufacturer of compounded bevacizumab. but it could just mean of the drug pre-compounding.
It could, but it didn't. If it assists.
Yeah.
Sorry?
It could, but it didn't.
Oh, well, okay, that's fine. I'm great. You've got what you want from Mr. Locke.
Presumably the drug is patented, so you can't go and find it manufactured by any old manufacturer.
Thank you.
Since we're on that letter, just the final paragraph, we look forward to working with you towards successful region-wide implementation. So, 501, do we know who the manufacturer is? It's mentioned in the letter, and then over the page, how would the MHRA respond given this would appear to clash with their own rules? Then you can go back, I think, skip over to page 499 at the top. This goes to my point about seeking to reassure about legal uncertainty. We've agreed to share a document from our QC detailing the legal niceties too. And then we can skip over, I think there's more advice to QC advice helping on 498, but we can skip back, trying to take it quickly, to 496 as an important email, because this draws together the concerns which this email beginning about halfway down the page says was discussed at great length at Chief Pharmacist meeting today. By way of very brief summary, these were the high-level points. Process had gone totally outside recognised DUMO processes, that's medicines optimisation processes. Policy needs to be taken through these established processes. Group got the finance elements, but needed a decision that not only reflects clinician responsibility, but also the pharmacist responsibility that exists when procuring unlicensed product. So the pharmacists there are expressing concern that, as I read it, that while some thought had been given to, particularly in the clinician Q&A, to the position of clinicians, pharmacists are expressing serious concerns here about what they're potentially being asked to do and exposed to. It says, this is important in the brackets, apparently Avastin would be sourced in multi-use vials. I thought that it was single use, therefore classifies as unlicensed, not off-label. It falls under the category of manipulating and producing a special, well, technically it isn't a special, but leaving that to one side. As the pharmacist procuring has an equal duty in law, all FAQs refer to clinician's responsibility, not pharmacist's responsibility. And that's a point that my learned friend Mr. Delamere will be developing, but it is an important borderline that's being flagged here. Clinicians did not link with all ophthalmologists, etc., etc. And then the last bullet is important. Requesting a QC, a quality control audit on the proposed manufacturer. So again, we have reference to a single proposed manufacturer.
Does QC always mean quality control?
Well, I thought it did here. It's true that the term QC is also used in the legal sense earlier in this exchange, but I think a QC audit, well, I think it must, I'm afraid I'd assumed it must mean quality control there, not learned Mr. Locke providing an audit on the proposed manufacturer. Despite his many capabilities, I don't think that would be his bag. He's nodding.
Well, it's speculation. I can't tell you, but I think that I would read the email in the same way as my own friend does.
Yes, no, so do I.
So, my lord, my third point is, what do the documents say about cost? And this is, I've already shown your lordships and your ladyship, the policy itself is based on an alleged price of what's called Avastin. We wouldn't accept it's properly called Avastin, but putting that to one side, of about £28 per injection. And that's contrasted, as the court's seen, with the list price figures for Lucentis and Eylea. Now, all of those figures are contested, but the short point is that that cost cannot be on any basis other than multiple syringes of bevacizumab being made up from one vial of Avastin and sourced from a bulk supplier. And the cost of so-called original vial use we get from, which would be much, much higher, we get from the CCG's own evidence, helpfully, and the best place, in various places, the best place to go is Mr. Ray's statement, which is in Supplementary Bundle A at tab 9, page 144. And I think I should show you.
Can I just be clear about the target of these submissions? You say, be on any other basis other than multiple syringes and source from a bulk supplier. In other words, a bulk supplier making up syringes, packaging them up for individual doses and supplying them to
We do.
And though, perhaps just following up, my lord, those are in fact two separate questions. Speaking for myself, it seems to me completely obvious that these figures, however contested, can't be based on what the judge calls mode 1, because there you use only a very small portion of the vial and throw the rest away. But the difficult bit, not the difficult bit only in the sense I haven't understood how it works, is the second bit about bulk supplier.
And that's
That's where you're
absolutely
going.
fair enough, my lord, because I haven't said what I'm going to say about that yet, and Mr. Delamere is going to say much more about it, but I am coming to that. I think before I do, though, I should just show you the figure, just to make that point good. It's at tab 9 in Mr. Ray's statement on page 144. Sorry, Supplementary Bundle A, tab 9.
Particular paragraph or page?
So, the paragraph for the price is paragraph 13. It says at the end, the price around £291.
I mean, that figures in the judge's judgment, isn't it?
Yes, yes. And coming back to my lady's question earlier about, well, do we know anything about how many vials you could actually extract from, perhaps how many syringes one could extract from one vial of Avastin? We get some information about that at paragraph 11. So original vial use would involve using 100 milligrams in 4 millilitres of bevacizumab, withdrawing a small volume of around 0.2 millimetres. So that's about 4 times what one would need, because then explains normally a dose of 0.05 millilitres would be injected into the affected eye. Of course, you need more than you're going to inject to ensure it can be done safely and any air expelled and so on. So the syringe is overfilled, but a small volume of about 0.2 millilitres. One sees that figure in other places is typically what is being put into these syringes. My very back of the envelope calculations tell me that, well, if you squeezed every drop you could out of a syringe, not not leaving the extra that you would need to leave. I think I'm right in saying you could get 80 doses,
80.
80 from a single vial, but what Mr. Ray's explaining there is that actually they would draw up more than was needed, and I think that's done similarly when it's aliquoting. But
So it's
you
up
could,
to 80.
up to 80.
But if he's right about 0.2 millilitres, that would be 20.
Yes.
Yeah.
So maybe the most we can say is between 20 and 80. But it's certainly a very different, of a very different order. My lord, there is a merits point here, if I may, because we say the CCGs can't have it both ways. On the one hand, they say on more than one occasion in their skeleton that what we're trying to do is to stop the NHS saving the figure of £500 million a year is bandied around. I have to say we have no, as far as we know, that figure has no evidential basis. It's actually a figure that comes from some press reports. But be that as it may, they say that, and then on the other hand, they say that the policy leaves the trusts completely free to do what they want and could be implemented through original vial use, which would, as we've seen, have costs of a completely different order. Not to mention totally ignoring all of the costs of additional clinic time to obtain consent and other additional and associated costs, we say, and there is evidence on that. Just for your note, a good place where that's gathered together is in the third witness statement of Mr. Schwert, paragraphs 29 to 32, supplementary bundle A, tab 3, pages 41 to 43.
He also says 40. It's around
Did you say 21, 43?
40.
And Ms. Mackenzie helpfully reminds me that in that same witness statement, Mr. Schwert refers to there being about 20 syringes obtained from one vial. So I think between 20 and 80 is probably a useful ballpark. That's at paragraph 14 of Schwert 3. Now, as we've seen, a number of other figures are bandied around for the levels of cost saving in the contemporaneous documents, all with no real explanation or justification.
Are we still on the merits point?
My lord, yes.
We may run out of sympathy on the merits point.
The important point, my lord, for present purposes, is that the level of claim savings is only consistent with supply of CB from established external suppliers. And I know that I've made my point about original vial use. Coming on to mode 2, if I can, just before the short adjournment, we say it's not consistent with internal mode 2 supply either, as that would require considerable capital expenditure from any trust prepared to contemplate developing their own facilities, as well as totally uncosted operating costs. Now, plainly, mode 2 internal supply is not what the chief pharmacists of the trusts were envisaging in the email exchanges we've just seen, because they were referring to a single manufacturer and asking who it is. But there would be other costs associated with the other ways that it's now suggested the policy could be implemented. So in particular, and just to anticipate a point that I know is going to come to the fore in Mr. Delamere's submissions, if a system of prior prescriptions were introduced, that would bring with it additional costs. Because, for example, patients would need to have an additional clinic visit and a prescription issued before the purportedly lawful compounding of bevacizumab could be undertaken. Cost savings were the whole rationale of this policy, as the judge recognised at paragraph 3 of the judgment. So this isn't some unimportant aside.
So you're saying that if there was the prior prescription method was used, there would need to be a prior prescription and a aliquoting exercise for each injection.
Yes.
Why can't the clinician who's got the patient in the clinic write out a prescription, send it round to the pharmacy, and have it dispensed all in one sitting?
Well, yeah. Certainly the pharmacy has to have it in their hand before they can lawfully compound aliquot.
Is that right?
Well, this is really trespassing into Mr. Lemaire's territory, but that's our reading of
These
Apposite.
injections, how are they usually administered in hospital, or can
Yes.
you have it done in your GP?
No, my lady, we're talking about all
It has to be
hospital.
done in hospital.
Yes. These are intravitreal
Is it daycare?
eye injections. Yes.
With an anaesthetic, presumably. Of some sort.
I'm not sure that. Uncomfortably, I'm not sure that one is.
No, surprisingly. But very professionally and sensitively done, of course.
Well, I would certainly hope so.
This may be a big question, in which case perhaps you'll want to do it after lunch, but you are saying that mode 2 would require considerable capital expenditure by trust and operating costs, and you've gone on to make a particular point about a particular kind of operating cost, namely that associated with the extra visit required for prior prescription. But at the moment, I haven't seen where you get the proposition about requiring considerable capital expenditure from. You are about to give us a series of references
I
to
accept-
that, are you?
Yes, I was actually. This point comes in two places. I was actually going to come in most detail under my third point, that even if the judge's approach was correct, we still say it's not realistically capable of being lawfully implemented in this way. And I was then going to take the court to the evidence that we have on that.
Okay, well, let's
But
do
it can come under either.
I don't mind where it comes,
very
as long as I know it's coming.
I had hoped to be finished by now. I haven't. I've been through all of the authorities I wanted to take the court to. I've got a series of, I hope, fairly short submissions just to
That'll
conclude on
have to be
ground
a
one.
negotiation between you and Mr. Delamar, because he's the loser. I think we will be
Well,
quite tough on the appellants as a whole going over their estimate. But I'll leave it.
I know he's got a lot to
You
cover.
can
and I
negotiate that with him
I
over
am-
lunch.
going as rapidly as I possibly can and will continue to do so.
Very well. Well, let's sit again at 2 o'clock.
Grateful.
Guys.